funneling, as we know, this really for me demonstrates that funneling between police report and what ends up going to court is the big gap, so that then when things go to court, they are more likely to get a guilty prosecution. And then these are the sentencing as a result. So the majority it was a custodial sentence. But you'll see that in the blue on the right, but you'll see on the left in yellow that 17% it was community supervision or work orders. So when you cut that down to basically custodial and non-custodial, it's about 2/3, 1/3. So keeping that in mind in terms of reporting, for me, some of the and I've called these non-legal aspects around consent, but there's a whole lot of community assumptions about consent. And the idea about consent is often in the community that it's assumed to only be about kind of younger people. And as I age, that's kind of, I think, 40 or 45 and under now. I'm increasing that each year. It's often people think about it as younger people who are having casual sex, early stages of relationships, navigating relationships often is how it's seen. And women are still and a big part of the consent issue is still about women being seen to put themselves at risk, using dating apps, drinking too much. So the rape myths, I think there's some shift, but we actually still are living with quite a lot of those when you scratch the surface. And we saw that in those, recent cases, particularly more with, I guess, Brittany Higgins and Grace Tame, because it wasn't child sexual abuse. So when we think about consent, often people are not thinking about long-term couples, and they're definitely not thinking about older people in various supported accommodation. They're not thinking about women with disability, etc. So I think that the way that consent is thought about is also very much about an interaction between two people who are younger and don't almost know what's required or what are the rituals of what's happening, rather than a more deep understanding of what's going on. So then what happens is consent can often be reduced to an individual activity per incident. And so it gets considered to be something like a miscommunication. They didn't know, they thought that, we didn't understand. So what we do in those situations then is we erase the socio-political context of what's happening. And for me, that's much more linked to kind of issues of power and control and the different differentials in power based on a whole range of things. So when we talk to people, they talk about consenting to unwanted sex, or consenting but not to that specific act or sexual behaviour, and that uncertainty about whether they even wanted sex in the first place. So I think that we're dealing with something much more complex and political than often this idea of an individual yes-no negotiation. So whilst we aspire to consent as a kind of expected or normative social sexual practice, we're not actually going to, and I quite like this quote by Hirsch, that we're not actually going to get to an effective promotion of consensual sex as a strategy until we modify the social structures that shape the processes and practices around consent. And we can't rely on legislation. But that, for me, also overlooks the role that legislation has in changing, social attitudes, behaviours, etc. So I think we also need to think about the law's role in kind of social change and social innovation as well. And I think we see that in WA around the image-based, the non-consensual sending of images, etc. So I think that we can start to sort of use the law more than we have so far. I won't go through these, people are pretty familiar with them, but all of these kind of things are the sort of social structures which we need to consider consent happening within, rather than two individuals who are kind of, generically equal and able to negotiate and communicate this, and one disagrees. So all of these things, again, things like drunk sex are often associated with early relationships, and not seen as kind of part of and it's, yeah, seen as excused. And I guess finally at the individual level of interaction, that everybody's making these assessments of individuals in the shadow of rape myths. So I think, all of these things, and we saw that, say, in the Brittany Higgins case, and I'm using it because it's close to mind, around one of the jurors wanting to accessing that paper about women who report sexual assault, false claims, basically. I think the thing that we're always going to struggle with, and the law struggles with constantly, is the nature of events, is that they are often private, and recounting of those events is always going to differ. So how we kind of manage that in an idea of objectivity and evidence. And because courts are mostly based around the judgment of incidents, both in DV and sexual assault, we often overlook the likelihood of observing patterns over time and patterns with multiple victims over time, particularly where there hasn't been convictions. So we lose sight of clusters of actions that perpetrators have committed over time. And we don't really get to look at the whole area of sexual assault as humiliation. Within the context of domestic and family violence and coercive control, within like that, again, that can sort of be stripped out of what's going on when we just focus on these notions of objective incidents. And I guess finally, the things that we kind of know to set the scene are that victims are understandably reluctant to go to police and courts, although, promisingly that is increasing. And that's about process, low conviction rate, what they've heard others say about those experiences. Intersectionality, I think, is really important in this context, and access to justice is an ongoing issue for women, particularly around women that are disadvantaged in various ways and excluded in different ways. So that's my kind of setting of the scene. So I'll leave it there for you.
Thanks very much, Donna. I really appreciate you giving us that context, and particularly highlighting the intersect between the social, legal and community attitudes. Now we're going to go to Hayley Foster. Again, Hayley is the CEO of Full Stop Australia, an organisation many of us here know, and Hayley has had many years' experience in policy and practice and law reform. In fact, I can say this for all of our speakers today. And Hayley is represented on different national policy groups, including the National Women's Safety Alliance and the National Plan Advisory Group. And Hayley is going to give us the national context, and in particular talk about the inquiry into sexual consent laws that are happening around Australia. Thanks, Hayley.
Thanks so much, Alison, and thanks everyone for having me. I'm on unceded Aboriginal land of the Gadigal and Eora people of Gadigal people and the Wongal people of the Eora Nation, and I want to pay my deepest respects to elders past, present, and emerging, and on all of the lands on which we all meet, and everyone who's on this call. Thank you, and acknowledging and paying respects. Thank you for the opportunity to participate in this. We're incredibly passionate about the reforms that we could potentially be having in WA, and we're really thrilled to be part of the conversation and see how we can support that in any way, shape or form. As a national service and with the National Survivor Advocate Program, we feel we might be in a good position to sort of just, get WA to have a look. You get the government here and the Law Reform Commission here to have a look at what's happening across the board and to learn from the experiences we've already had so that you can adapt it to your context. As everyone would be aware, we've recently had a change to our laws in New South Wales around affirmative consent. I'm based here, as I said, in Gadigal land in Sydney. And so we have had it was quite a fight. It was quite a long journey, and there's a huge amount of work, all the roundtables, all the discussion papers, and all the things that you're going through now. And also been contributing to the Queensland Law Reform Commission process as well as the Victorian one. And so we've been kind of thick in it. And I think there have been a few key things that I think we can take away, and that, affirmative consent models can work. They can work in practice. They're not something to say that, you're going to all these accused are going to have this unfair situation where they're, we're going to have all these prosecutions, unfair prosecutions with these lying complainants left, right and centre. We know the sky's not going to fall in if you have an affirmative consent model. That's probably the first thing I would say. The second thing, and Donna's touched on this really well, we have a whole range of other reforms that have to come with this, but let's not lose sight of the fact that this law change, and it was similar with coercive control, this law change has the power to change social norms and expectations, and we're already seeing this, the result of that as a result of having this law in New South Wales. And it's changing practice. We're getting massive increases in people coming forward to report sexual violence to police, whether it be just to make a record with police so that they've got it on there and they can look and they can find these repeat offenders, or whether they're actually going through to prosecution. We've got a much more prosecution stance as well with police, actually wanting to take these matters forward, because it is a much more friendly consent when it comes down to he said, she said, or whatever genders they are, we're much more likely to prosecute now. We're much more likely to go through that process, provided the victim wants to go through that process. So it's been really powerful. Some of the kind of sticking points were around, and in Queensland, it's a similar thing as WA around mistake of fact. This special verdict one is also just, forgive me for calling it archaic in this context, but it's just it's a way out. And we had similar kinds of approaches, and it was really interesting. They weren't really public about it, but the Bar Association were really big on this mental health loophole is what we call it. But really on the reasonable test, they were basically saying very clearly in legislation that if somebody has a mental health condition or cognitive impairment, and then they went through to list them, and an example of a mental health impairment could be that they experience anxiety or depression, that the steps or the requirement to take steps to ascertain the other person's consent wouldn't apply. That person, and it was a very tenuous link, and that person, the affirmative consent, the whole centre of the affirmative consent of the law wouldn't apply. So we worked really hard on that campaign. Actually, an interesting fact, One Nation's Mark Latham was actually the person that picked up the phone and gave me a call and gave me some unlikely support at a particularly interesting time. So anyway, that's just a fun fact for you. But, I think that that's been a really important part, because as we know, day in, day out in court, that's what we constantly see people get off on, the mental health. Cool. How easy is it? I know it's like, sorry if there are any clinical psychologists and psychiatrists in the room, but the reality of being able to, and particularly if you're someone of status and wealth, to be able to find a practitioner that says, oh yes, it was, he was going through a really tough time, and, was not thinking clearly and was not able to kind of, communicate in that way because he was just deeply in a deep state of trauma. So, it is very easy, and we see it day in, day out. And I don't mean to be kind of, whimsical about it. But sometimes you're going to either scream and cry and sob, or you're just going to have to, like, at some point, poke a hole in the ridiculousness of this whole situation that we're finding ourselves in. It is ridiculous. 1.5% of sexual assaults in this country resulting in a conviction is outrageous. That is not a justice system. And we know that, unlike the reforms, and I have to say there's been incredibly important reforms in domestic and family violence. There's so many people on the call here who have really been spearheading that work to get some really great reform. We're seeing an impact. And, I know that there are problems with the personal safety survey, the ABS personal safety survey, but it does ask some pretty blatant questions and get some pretty blatant answers. And what you can see is progress when it comes to intimate partner abuse and domestic and family violence. And you see progress when it comes to sexual harassment in the workplace. And we see a continued increase in the actual self-disclosed, reported, surveyed, answered questions of people saying actually more people, from 17% to 20% in this. So that 17% of women, have gone up to 20% of women now have experienced sexual assault since the age of 15. And as we know, the exponential increase in sexual assault reporting, which is welcome, but we're talking about 110% increase in reported sexual assault in the last 25 years, when every other major crime category has plateaued or gone down. Every other. So when we do a graph of this, it's like all the other major ones. Domestic and family violence has been, really belligerent, and then sexual violence has been doing this. So we have a massive problem. The justice system is entirely broken, and I don't think that this government or the Law Reform Commission can get away with not having an affirmative model of consent and with actually addressing these archaic loopholes that are basically a free kick to perpetrators to keep going and keep on doing what they're doing, and for victim survivors to be torn to shreds on the stand and destroyed through the process. So I think that's really important, and I don't think we should lose sight of that, but also not in the detail. We're talking about those specific provisions where we know there can be a loophole. They will exploit it. So we have to be vigilant, and we have to address some of those issues around mistake of fact. Mistake of what? Fact what? I mean, if you've got cognitive ability to understand, you can't mistakenly sexually assault somebody. And just, it either is or it isn't, so I think we need to just be a little bit blatant about that. Some of the submissions we've been making have been around, whether we actually have to deal with an entirely different system, because it's the stuff that Donna was saying, really, and I constantly quote Donna because I've been fangirling her since I was at uni. But basically, it has to be the case where we have to question this entire system, because an adversarial model, when there's such a power differential, is highly problematic. And so it's the same as the family court process. We have to look at, is this adversarial system set up to achieve justice and to make that possible? And I would argue that it is not. And I think the last thing is that let's not lose sight of those really important things like jury directions. Let's not lose sight of what evidence. I mean, ultimately, we need specialist judges in this space. We need specialist prosecutors, specialist practitioners. But we need to make sure that, at the end of the day, we have to make sure that they have the evidence available to them to make the call. And that's what they will say day in, day out. We have a presumption against admitting any tendency or coincidence evidence, and you have to, pay your way trying to put that forward before the court. It doesn't happen in practice. I'm dealing with so many matters here in New South Wales where we're dealing with these on appeal, and that evidence is not being admitted, even in child sexual offence matters where they've flipped that presumption in New South Wales and getting really great results and outcomes. But there's massive pushback, even for children, for there to be admitting really serious repeat offending of child sex offenders not being able to actually admit that evidence. So they're the kind of slippery things that we would say keep an eye out for it. We need to not lose the detail, but please don't let them argue, we certainly won't, that we need to have these archaic, mistake of fact, special verdict, all of this. If we're dealing with someone who genuinely has a cognitive impairment, we're dealing with a completely different situation, but that's not who we're seeing coming through our courts. So that's probably just my first initial, but if you wanted to move on to the next person, I'm happy to take questions or engage at the end.
Great, thanks heaps, Hayley, and for your passion, your advocacy, and for letting us know that Mark Latham is your BFF. That's great. We will file that one away for another day. So now we're going to go around Australia, or probably around half of Australia, and hear from the perspectives of those in different jurisdictions about the reform journey in their respective state or territory. And in particular, what were the most important issues? Were there any challenges, barriers? What were the wins and what were the shortcomings? And we're going to start with Tasmania. Yvette, are you there?
Thanks, Jenny. I am here.
Oh, you are.
I was hoping you would go to me first, but there you go.
Okay, great. Yvette, just let me introduce you. So, because some people don't know you, I know you. So, Yvette Cattell is the CEO of Women's Legal Service Tasmania. She's legally trained and has worked in government and non-government roles, including the Tasmanian Aboriginal Centre and being a Legal Aid Commissioner for 8 years. Thanks, Yvette.
Thanks, Jenny. And I was really interested to hear what Donna had to say, and wanted to kind of start by saying we've come a long way. One of my roles was to work for the state attorney when we tried to, I went back and looked at Hansard and was newly enraged and horrified. by a parliamentary debate in 2003, which we looked at introducing a free agreement provision to our consent provision in the Tasmanian Criminal Code at the time. And it was dressed up by, I'm going to say blokes in the profession, because the Law Society opposed it, the Tasmanian Bar opposed it, the Judiciary opposed it, the DPP opposed it, and they all came out saying that introducing the kind of criteria that we've now got in our Act, some of which has been more recently revised, where you had to actually make sure that you've got a free agreement between the parties to establish consent in a rape matter, equated to, and I'm quoting what the shadow attorney said at the time, that it was an unreasonable and often impossible burden to place upon an accused person. And they all agreed to this, and it goes too far and reverses the onus of proof. And in respect of some alleged circumstances, is not indicative of a lack of consent. And it even includes a bit about, you know, what happens if you agree to have sex with Russell Crowe and then in the morning he tells you he's not interested, and then all of a sudden you can be charged with rape because there isn't a consent because you've been overborne by the position. So I guess I'm sharing that because there's been a really long debate, like that was in, I think, 2002, that this kind of active conversation that Donna and Hayley have talked about around consent and what constitutes consent is, we have in Tasmania a provision that says that consent is a free agreement, and a failure to say or do something to communicate consent, you know, isn't okay. So we require this test in effect that it's a joint activity, or I think, Hayley, you used the term, or I've heard you use it, about enthusiastic consent. It's not something one party does to a person. It is a joint enterprise and activity between two people, and that can, you know, consent can be withdrawn at any particular time. There have been problems with that in the way it's been applied in Tasmania, and it was really interesting to see Donna's statistics about not only what gets to court but how many convictions there are. And there was a really, I should have written the citation, but there was a case in Tasmania where Women's Legal Service and SAS, the Sexual Assault Service, joined forces to be very openly critical of a sentencing case. It was prior to us having the stealthing provisions, because the other thing I'd say is that Tasmania copied the position in the ACT with stealthing to make it unlawful for, and it was a kind of pick-up of the ACT provision of the removal of a condom during sex, and saying that it didn't constitute consent if it came off basically during the activity without consent. And it so that was interesting. But this particular case was about two young people. One of them, the perpetrator, was, they were both about 17. The perpetrator at the time of the offence was found to be guilty by the jury. There was some premeditated elements in that he set out at the start of the party to tell his friend that he wanted to have sex with this young woman, proceeded to watch her get drunk, dragged her into a bush during the course of the party, and she was raped. Now, the interesting aspect of that legally was in the sentencing, the judge put a lot of priority on the fact that he didn't ejaculate and he wore a condom. So therefore, you know, he got a suspended sentence. And I came out along with SAS and said this doesn't meet with community expectations, it falls short. And actually it's completely irrelevant to take those two factors into account. There was an active conversation, and I was really interested to hear Donna to talk about this, you know, within our Women's Legal Service group, about whether it should have been, an aggravating factor that this particular young person, the perpetrator, came from a good family home, because I thought, well, if the perpetrator had been an Aboriginal person, there's no way, I don't think, that, or from a called community, that they would have got a suspended sentence. But because they went to a good school, came from a good family, this was all in the comments on passing sentence, and I'll share the citation after. I should have looked it up. So even though it wasn't called mitigating factors, they were actually used in that way to reduce the sentence of the young person. There was no account of the fact that he'd had a very privileged life. So I think that the way the law often gets applied is really challenging. So I hear what you're saying, Hayley, and I am a proponent that we do need to get the law right. But I think there's a deeper problem, which Donna really talked to, about the cultural and political and social factors that sit behind the offending. And for me, the really big aspect of that is the gender inequality in the driver. And again, this is what allows sexual harassment to be so prevalent in our communities across the country. We only have to look at the Jenkins report to say, I think it was 1 in 3 women were sexually harassed in the 12 months preceding that report, that it's really prevalent and accepted normative behaviour in Australia to have those kinds of attitudes and to voice them and say them to women. So I think, and I am using gendered terms, but of course there's other, other persons can have a similar impact. But I do think there is a gendered story in that, and it is very tied up in power and in privilege and who makes these decisions. And when I look back at that Hansard, when we were talking about free consent, all of those statutory positions were held by men, or the laws were written largely by men, for men, to protect them. And I still think that there's a really strong hangover from that, and I'm really supportive of affirmative consent. But I'd almost encourage a step further, and people see this as quite radical, but I wonder whether, given how bad the rates are of reporting, the conviction rates when we go through the court, about why can't we do a reversal of the burden of proof so that the perpetrator has to prove that they did in fact have consent? And why are we so scared of doing that when we know that the justice system has failed women by not approaching it differently? And I was reminded of that kind of radical position when I read that that was what I was accused of some 20 years ago, working in the ministerial office. Now, a last aspect, I think my time's nearly up, I'll get the bell in a minute, to say that causes us some challenges in Tasmania is that we've got the consent provisions that sit in the Criminal Code, and then we've got a Family Violence Act as well. And the approach or the framework in the Family Violence Act in Tasmania is one of pro-intervention. So it really is kind of a disempowering kind of model, and it was intentionally done like that to take the focus off women having to proceed with charges, because we knew there was a similar kind of history to what Donna's outlined in relation to sexual offending in terms of the projection of matters going forward, because women withdrew their cases. So there was a pro-intervention model that was introduced in the early 2000s in Tasmania, and that the rub with that is it makes the sexual offending component, where the family violence has a sexual assault component, which we know from our clients is often the case, but it can be quite disempowering. So the intersection between the Criminal Code and the Family Violence Act is something that we're still trying to work through in Tasmania, and we're trialling a new multidisciplinary centre that's kind of led by the police, and we still haven't worked out that threshold issue of where it sits, which concerns me a little bit, because I think police's approach to that is to say, well, it doesn't really matter what the victim's survivor wants to happen. But I think sexual offending is different in that I think people have already had so much of their agency and so much of their will overborne that we do need to look at it perhaps a bit differently. So that's a bit of a sticking point. We also do have this great offence that the current attorney introduced.
Hey, is there?
I'm about to wrap up.
Okay, good.
Can I just one last point?
Ring.
And
okay,
then I'm at the end. I could
Okay,
say
good.
more. We've got an offence of persistent family violence, but again, I heard what Donna said, and it is about convictions. So there is a criminal code offence for persistent family violence, which can include sexual violence, but it is only where we've got convictions. It can't be allegations. There's a lot more I could say, but that I might wrap it up on that note. Thank you.
Yes, thanks, Yvette, and I'm sure there'll be a chance to contribute more when we go to questions. And Yvette, you can leave your camera on if you want, so we can just see all the presenters. And thank you. I'm sure the idea of a reversal of the burden of proof is not radical to most of us on joining today, and thank you for in particular highlighting that the dynamic of gender inequality runs through all of this. And thanks, Hayley, for your comments as we're going along. So now we're going to go to Queensland. Nadia Bromley is the CEO of Women's Legal Service Queensland, and Nadia also has diverse practice and policy experiences as a lawyer, including practice manager at Legal Aid and general counsel at Q Super. Thanks, Nadia.
Thanks so much, Jenny. So I come to you from the lands of the Yagara and the Turrbal people today. I'd like to pay my deepest respect to their elders past, present and emerging, and my particular respect to First Nations women and the traditions they carry. Friends, I feel slightly anxious about speaking for all Queenslanders everywhere, but I'm hopeful there are no others in the audience, so I might get away with it today. The three topics I wanted to cover briefly is sort of the Queensland journey, because we're at an exciting point, but I think it's to remember how we got here, some of the issues we've had and what the future looks like for Queensland. So like Yvette and everybody has touched on, the reform journey in Queensland's also had a long arc. So the original task force in Queensland was actually in 1999, where they reviewed the criminal code. And that report was tabled 22 years ago last week. That talked about changing the rules about cross-examining women about sexual history, about special witness provisions, about the definition of consent, which still hasn't changed, about that courts should look at what positive steps were taken to ascertain consent when a mistake of fact is raised. That hasn't been implemented. So that report was tabled. We saw some change. Many years after that, we had the Not Now, Not Ever report in 2015 that made 140 recommendations. We high-fived ourselves in 2019 and said we'd implemented all of those, and those 140 appear in the 277 recommendations we saw last year and this year in the Hear Her Voice reports. So there is sort of a cyclical nature of some of this, but there is good news on the way. The two other points I wanted to talk about in terms of the journey, I think a really important point is about the protected counselling communications. That goes by different names, but you'd all appreciate that's where we try and prevent victims' sexual assault counselling notes forming part of the trial, essentially to discredit them. That law came into effect in Queensland in 2017 amongst a hue and cry that was the end of justice as we know it, and that, you know, people would be deprived of a right to a fair trial. Our service has represented more than half the women who have made applications in relation to that since 2017. And as far as I'm aware, only once have counselling notes not been brought before the court. So I think it's important to remember sometimes what the law might do, what it's alleged it will do, and what actually happens in practice can be very different things. In 2019, our Queensland Law Reform Commission did a review of consent and mistake of fact in similar terms to the one that I've seen in WA, and they looked at all the rape and sexual assault trials in 2018, so they decided that was the best way to look at the data. It's important to note when you think about this, because they looked at every single rape and sexual assault trial in Queensland in 2018, there were 135. That was it. That was the data sample. So the Queensland Sentencing Advisory Council last year did a report, a 16-year report about rape and sexual assault from 2005 through to 2021. And it does show that the trend is increasing and has since 2005, but it's important to remember that only about 140 people are sentenced for rape in Queensland every single year. So even if the heinous outcomes were to occur that we're talking about 140 people here against the entire population and some of those gendered issues and societal discrimination we're talking about. So to the technical legal issues, there's probably three I wanted to touch on. One of them is the interplay between the offences of rape and sexual assault, and reading the papers, I understand that's an issue for WA also. It's not necessary to go into the details, but there were some historical complexities even associated with consent. So it was only in 2021 that the definition of consent was amended to apply to all sexual offences. Prior to that, many sexual offences were left with the subsidiary definition of consent arising from assault. So pub bar fights was the origin of all the case law on that, and that was being used to apply to sexual assault. That's just completely unsatisfactory. Regrettably, in Queensland, as it currently stands, consent is still given. That is horrible language, and it has a horrible effect in the courts. And there is a list of factors which vitiate consent in, as many other jurisdictions, so force, fear, fraud, etc. But one of the issues that's arisen across time in law reform and in cases is the fact that doesn't even say it's a non-exhaustive list. And in the Queensland Law Reform Commission report, they said that one of the key strengths of the criminal law in Queensland was its combined certainty and flexibility. Look, I think history shows us and women's experience shows that that's actually a paradox. Those things don't naturally coexist. And I'm reminded of what Justice Brennan said when he was talking about the ethics. And he said, if you reduce the rules of ethics down to a black and white rule, spiritless compliance will soon be replaced by skillful evasion. That's true of codified laws, is that the more we sort of tighten it and try and get better outcomes for women, the more black and white it is and the more room there is to avoid it. So I think it's really important to think about that nuance. And mistake of fact was the final technical point I wanted to talk about. The Queensland stats are really interesting in this space. So in that study I talked to you about, 135 trials, mistake of facts was raised in 47% of those cases. And of the defendants who raised mistake of fact, only 29% were convicted. I don't know what the opposite of compound interest is, but that's what happens when you prosecute sexual offences. It just gets smaller and smaller the further you go along, like some kind of horrible doll. So 29% of people. And in trials where the complainant actually gave evidence of objecting, so it wasn't that there was freezing, it wasn't there was silence, it wasn't that she was asleep, she gave active evidence that she was objecting to the conduct. In 40% of those cases, mistake of fact was still left to the jury. I think it's those kind of stats that bear out it doesn't matter how you structure the law, prejudice comes in over the top. And I think the other really interesting stat is last year in Queensland courts, sexual offences still had the lowest conviction rate of any category of offence. Of all the sexual offences that were prosecuted in the district court, 50.8% resulted in a conviction. That is just terrible. But in good news, the future for Queensland. So the reforms proposed and agreed to by the Queensland government include affirmative consent. And the way the Queensland government proposes to go about that is on a limit on the ability to raise the excuse of mistake of fact. So I understand in WA there's a discussion about whether changing the defence or excluding it. Queensland's gone with a different model of a threshold that you essentially can't raise the defence of mistake of fact unless you lead evidence of what you did to establish consent, which is, you know, an interesting middle ground. And to Hayley's point, I think jury directions are really important, not just for the juries, but also for the judges who have to read them out, because I think it's important to remember that the judiciary forms an important part of the prejudice or lack of in the courtroom. The one summary comment I would make, because I'm sure, Jenny, you need me to be quiet very shortly, is some of the most common and impactful changes that we've seen in Queensland have resulted from expanding non-exhaustive lists in the code. Pressing, but to codify to the extent that you can, but reduction to black and white parameters doesn't serve the interest of victims. So we are always going to need guidance for courts. We're always going to need to be able to amend, give examples, give jury directions. So it's that infrastructure that sits around the law that actually makes it useful. Thanks.
Thanks, Nadia. I think you get the gold star just for role modelling. Kind, very well done. Thank you. It is quite depressing, isn't it, when we look at those stats and those conviction rates and we think about the barrier that community attitudes poses regardless of any change in legislation. Now we're going to Victoria and we have Lara Frieden, who's the Executive Officer for Women's Legal Service Australia. So Lara's had a range of strategic advisory, advocacy and policy roles, including with Women's Legal Service Victoria, Legal Aid and the current AG's office. And Lara was the advisor to the Minister for Victim Support in Victoria as well. Thanks, Lara.
Thanks, Jenny. Really grateful to be here today. I'd like to just start by acknowledging the Wurundjeri and Boonwurrung people of the Kulin Nation and pay my respects to elders past and present. So I'm here today speaking on behalf of women's legal services all across Australia, but I'll mainly focus on the Victorian context for today. That's definitely the area that I know the most about. So Women's Legal Services, our expertise is primarily informed by the work that we do with victim survivors of family and domestic violence. And so what I'll talk about today is our kind of expertise in that space relates to responding to victims of sexual violence within that context. So I think when talking about sexual violence in Victoria, it's really important to look at the huge reform that's already taken place. We've seen a Royal Commission into Family Violence, significant investment by the Victorian government into reforming the system for victims of crime as well. And so that means that victim survivors in Victoria do have potentially a more kind of holistic support service that they can access. We've got a Victims of Crime Commissioner, we've got a Victims Charter that has recently added a lot more rights and entitlements for victims. All of the agencies that work directly with victims have to comply with the Charter. There's reporting obligations. We've also recently seen an overhaul of our Victims of Crime Assistance Tribunal. So that means that victims will hopefully have more access to financial support and compensation to recover from crime. And there's also an increasing recognition of the need to invest in restorative justice options, alternative avenues for victim survivors to have their needs met. And there's also a government in Victoria that is just really committed to meeting the needs of victims. They've, again, made a huge investment. So I think it's important to look at that context when we're talking about legislative reform, because it really can only be, as many of the speakers have mentioned today, it can only be meaningful and have impact when we're looking at having a massive systemic reform, as well as trying to address community attitudes and making sure that the public is aware of different understandings of consent. We're challenging rape myths, we're challenging misunderstandings of how sexual violence occurs. So I think all of those pieces of the puzzle need to be considered collectively. So I'll give kind of an overview now just of the reform that's happened in Victoria. So at the end of 2021, the Victorian Law Reform Commission published their report on sex offences. It was over 600 pages long and it made over 85 recommendations for reforming the system. So it spanned across looking at things like affirmative consent and those legislative reforms to restorative justice, enhancing the Victims Charter, improving reporting, changing jury directions, all of the things that we've been hearing about today. One of the overarching recommendations was establishing a commission for sexual safety. And the government is looking at, well, they've agreed to do a 10-year sexual violence strategy. So that will include things like hopefully setting that up, running an education campaign, challenging attitudes about consent. And we're hoping that that'll also involve improving access to forensic medical examinations so that we can get that evidence, improving restorative justice options for criminal offences. So there's all kinds of things that we're hoping will be part of that to make sure that all of the recommendations of the Law Reform Commission are implemented. I'll quickly talk through the legislation in Victoria. So the definition of consent in Victoria as of the legislative amendments that came in last year is now free and voluntary agreement. So I think all women's legal services across Australia agree that we want consent to be about agreement. And as you heard from Yvette and Nadia, that's really around making sure that it's not a one-sided thing. It's both people working together to make sure that there's consent. So the way that the legislation works is it provides for consent vitiating circumstances. So there's a number of examples set out in the legislation of where there will not be consent. So the first one, and probably the most important one, is there won't be consent if the person didn't say or do anything to indicate consent. And so Victoria has taken that that approach, which is kind of colloquially referred to as the say or do something of response. And so that's around requiring the person to either have positively indicated consent. And then I'll talk to you about the kind of response from the perpetrator side of things. So there must also be a reasonable belief. that consent was given. And that's kind of our way of kind of retaining the mistake of fact defense, but in a different way. I mean, that's my understanding of it. So there has to be a reasonable belief that there was consent, and this will depend on the circumstances. And so it won't be reasonable unless the perpetrator said or did something to find out whether there's consent. But there is an exception to that, which is if there's a cognitive impairment or mental illness, then you have to say that's why you didn't say or do something to confirm there's consent. So as we heard earlier from Hayley, there's still kind of this loophole, I guess, around cognitive impairment or mental illness. So that's something I think that all jurisdictions have had to grapple with, and that's definitely been one of the biggest challenges in Victoria. And it's really been, I guess, the government trying to find that balance between what the criminal bar and the criminal defence lawyers and other kind of advocates are pushing for, as opposed to, you know, the sexual assault services and domestic violence services. And so that's where it's landed. One of the important things, I think, and this relates to Nadia's point around having non-exhaustive lists with examples, is that in Victoria there's specifically a consent vitiating circumstance that relates to family violence. So that's there will be no consent if the act was submitted to, that's the wording they use, because of force, harm of any type, or a fear of harm of any type, coercion or intimidation. So they've tried to kind of do a broad, expansive kind of example. And they've also stated specifically in the legislation that it can be a single incident or an ongoing pattern. And that's to try to reflect, you know, the ongoing dynamics of coercive control to make sure that they're covered. So that's just kind of a quick overview of the legislation. I also just wanted to touch on jury directions because that's such an important piece of the puzzle. And it's actually, I was reading through them all last night to prepare for this today, and it's really depressing kind of how simple some of the directions are. So for example, you can ask for a direction which is just to explain to the jury that non-consensual sex can occur within a relationship. And that's something that people might not know. So that's something that you might need to explain. Another one is you might seek a jury direction that a reasonable belief in consent cannot be based solely on a general assumption that a woman is dressed a certain way and went to a man's house. So that's another jury direction that is now in legislation. And there's a few more that are also you know, important to have. Like, for example, you can seek a direction that trauma might appear differently for different people. So, for example, you can't assume that if a victim survivor who is a witness is presenting in a certain way, doesn't appear to show, you know, the kind of emotion that you would expect from someone who has been raped, you can't therefore assume that they didn't consent, because, yeah, trauma can show differently. So, and another one is about continued relationships. You can't assume that just because someone stayed in a relationship with a person after the incident occurred that, yeah, it wasn't consensual. Have I gone over time, Jenny? I'll wrap up.
Yeah, just. But maybe that's a great segue. Thanks heaps, Lara, for that. And as always, we remain just a tiny bit envious of the progressive initiatives that are implemented in Victoria from Western Australia's perspective. So now our last state is New South Wales. Back to you, Hayley, and before we open it up for questions. And Hayley, I noted you also wanted to talk about juries, which you might want to talk about briefly here, and character evidence. Thanks.
Yeah, sure. So, you know, I think in the context of New South Wales, it is fairly similar now to Victoria. So a lot of those, you know, for the sake of time and clarity, I think it's really important not to kind of repeat, but pretty much those jury directions are almost exactly the same in New South Wales as they are in Victoria. The reasonable belief and the exception, the loophole I talked about, is similar, although we managed to get it has to be a substantive cause. So we're very pleased to have gotten that, to strengthen that as well. And we're already seeing a significant change in practice as a result of that. So I think that's an important one to look at. I did want to, in terms of going through the actual New South Wales Act, I think I don't know if that's going to be much of much benefit to you. We've more looked at all of the different models across the state, and I have to say most ours is pretty similar, and every time Lara was explaining it, I don't think it's going to be much use to you. What I'd prefer to do, if that's okay, is to talk about the importance of the jury directions and the way that they're used, because we didn't actually win on this one in New South Wales, but I think that we can at least push the envelope, and even if you end up with what we've got in New South Wales, then it's a halfway point, but making sure that we can admit this early. Also, we in New South Wales, our jury directions, etc., don't extend to child sexual offence matters. So this is really problematic, and so we need to make sure that just things like that inadvertent don't get dropped. But I think the other point to make about jury directions, and Lara, actually, I put this in the chat before you came to me, before Lara talked about it, but some of those community attitudes are highly problematic, right? We know from the National Community Attitude Surveys about the new ones about to come out from ANROS, and so we'll see how things have shifted and changed over time. I'd be interested as well, jurisdictionally, what the changes have been as well. But, we know, for example, when we're looking at the national community attitudes, that 1 in 3 people in Australia still think that a lot of time women who say they were raped actually led the man on and later had regrets, and 1 in 5 think that sex, it's because a man can't control his need for physically control his need for sex and things like that. So we have this. So how are you then going to have 12 humans from the general public that are going to stand up and provide a unanimous verdict when you've got the kinds of evidence that the court has before them and making that sort of a judgment? I think that's a really important point to hammer home when we're talking about these jury directions. It's like, seriously, dude, it's the bare minimum that people are having these things explained and going back to these things and reminding them, and being able to kind of remind people throughout the journey of countering those rape myths, and educating basic things like, just because you marry someone doesn't mean you've handed over all conjugal rights. So basic things like that need to be reminded, and that's where a lot of it ends up for us in New South Wales, is around the reasonable belief, the mental health loophole, and ultimately not getting over the criminal standard because of well, I just don't know that she wasn't asking for it. I mean, ultimately that's kind of where it lands. So I guess I couldn't. It sounds like not a big deal, but the jury directions make a massive difference. And we didn't get all the way in New South Wales. We'd like them up front. So if you can push for the educative function, obviously we think that we should have a more inquisitorial model. We think we should have specialist courts and really highly specialist judicial officers determining these matters. But if you don't get that, then the least you can do is some darn jury directions, and just referring to the national community attitudes. Just say, this is what general ordinary Australians think. So how is it that we're going to have a fair trial if we don't have these jury directions? So I think that's probably the main point that I'd make. Yeah, and Yvette saying the same thing. Is there any questions? Perhaps we could put it this way. Are there any questions around the New South Wales provisions that you would like to just test, comparatively in WA? Because perhaps that's more helpful than me kind of running through the actual provision.
Great, thanks, Hayley. That's you were certainly getting lots of nods there around the screen, and maybe we can start asking people to put those questions in the chat.
Yeah.
Or raise your hand. Or jump in. We can't see everyone on screen right now, but good time to go to questions and factoring in what Hayley just invited, if anyone has questions in particular about New South Wales. But I know Alison has got the first question to kick us off.
It was actually raised by you at the beginning as well, Donna, around the sexual assaults that are often, tactics of the domestic and family violence. And that there's increased reporting around that as well. And I'd be interested to hear from those of you who are sort of further along than we are, if you're seeing any evidence or examples of where we're seeing a difference in outcomes for victim survivors of sexual assault in the context of an intimate partner relationship.
Who'd like to answer that?
I
Is
can
it
get
Donna?
started. Were you about to jump in, Yvette? I was just going to say that, interesting the stats that Donna was providing before, like earlier, or something like close to a third of matters are domestic and family violence context. And, it's important to note that around 2/3 of matters of sexual assault matters in practice are actually in the context of those relationships. And so we're still not getting a high reporting rate of, if someone's in an intimate context. We are sort of seeing more disclosures in relation to, like, if they're reporting domestic violence, or if there's risk screening processes where they're being asked about any sort of sexual violence or coercion. We're getting disclosures in that way, but we don't have as much proactive policing when it comes to sexual assault either. And in most cases, as you know, and I'm just saying this to you, you are dealing with this every day, Alison, we're just saying, like, across the board, is such that women that we're supporting, or anyone who we're supporting in that context, usually don't want to talk to the police about the sexual assault component. They're happy to talk about physical assaults, verbal assault, stalking, all the rest of it, but don't want to go there with that. So that's why we see a much more of a volume of those that, perhaps in a dating context or in acquaintances, or, we're seeing a lot more, disproportionately represented in the cases that we see before the courts. I think it's improving. We pushed really hard for some provisions in New South Wales in relation to the jury direction around family violence. We lost when we tried to have a specific, we wanted a definitional and a guidance note on domestic sexual assault and sexual offending and domestic and family violence, and we did not win that. I believe you've got that in Victoria. You've got quite good provisions around that. We tried to steal those and put them forward to the New South Wales Law Reform Commission and failed. And then we tried to put them before the Attorney General and the Parliamentary Committee, and we failed for that too. But we would strongly recommend following Victoria in that regard, if at all possible.
Yeah, it's such a pity, that you didn't get that through, because when you refer to the NCAS, the National Community Attitudes Survey, we know from the last one that it's those attitudes towards sexual assault in the context of an intimate partner relationship that we're so slow in terms of progress, and so jury directions around that, I think, are really critical. Thanks, Hayley.
Yvette, did you want to jump in and say something about that?
Look, the only comment that I really wanted to make is that I don't think we can assume that a lot of people that are experiencing family violence, women I'm thinking of particularly, even understand what we know to be a sexual assault to actually be a sexual assault. And by that, I'm just continually surprised when I do community workshops by what kind of behaviours are accepted as normative. And I guess the one that jumps into my mind that comes up most commonly is that, mothers, young mothers generally, so it goes also to Donna's point, which I thought was really interesting, about how there's all these kind of assumptions about people in long-term couples aren't sexually assaulted, just saying, oh, we get it over and done with. At Mothers Club, we talk about how we get it over and done with early in the week, so we're not going to be nagged for the rest of the week. And I mean, that's almost verbatim, and I hear that kind of thing so often, which tells me, it feeds into the Anne Rose Community Attitudes Survey results, that there's a lot of behaviour that is just that is abusive, but that is accepted as being normative in our communities. And so that, goes back to my point about the inequality and how we've got a lot of work to do culturally in all of our communities to set the expectations about what is and isn't right. So yes, it's important to get the law right, but we need to have cultural conversations about what respecting relationships look like. And I think it needs to be locally driven. And I get a bit worried that, the Commonwealth's put all this money into national kind of programs, when I think there can be some really good local solutions to some of that. And I guess the only other thing I wanted to share is we do with Laurel House some kind of consent education training at schools, and the pushback that we get from parents and school communities is alarming about, regret sex and, basically victim blaming young women for the behaviours and activity. And these are generally you know, educated people that we would expect to have different views. So I think there's a really huge community education piece that sits around this, and I think it needs to be localised for different contexts in different states and territories.
Thank you. Thanks, Yvette, and thanks, Hayley. Hayley, did you want to comment on that? We have another question as well.
Just very quickly, wanted to say that there's low-hanging fruit when it comes to domestic violence and domestic and family violence laws and coercive control reforms when it comes to sexual assault and sexual offences in a domestic context. It's much more low-hanging fruit. It's going to be much easier to get access to justice for sexual assault in a domestic context if we were to use those provisions. And of course, it may not have the same magnitude in terms of the sanction, etc. But for many, it's going to be a much more accessible way to get acknowledgement and to get conviction and to have a sense of justice after sexual offences are committed in the context of a domestic relationship. Thanks.
Thanks, Hayley. Maybe we'll go. Tanya's got a question, and then we'll see if others on the panel can respond to Tanya's question.
Hi, Jenny. I hope you can all hear me.
Yes.
Look, thank you to all of the extraordinary panellists for sharing the stories, the stats, and more disturbing, you know, cases of the application of the law, poor application of the law, I should say. So I'm curious about a couple of things. Number one, which jurisdictions, and Hayley, by the way, nice to see you. How do we know which jurisdictions are more progressive, say, than WA? So, Jenny, you acknowledged Lara and, you know, Victoria, how progressive they are. How do we know which jurisdictions are more progressive? Number one. Number two, Donna, you shared the funnel. How does that funnel look relative, our funnel look relative to other states? So I'm curious about that. And Hayley, you talked about law reform being an opportunity to, you know, it's an opportunity to change attitudes. Yvette, to your point, how do we accelerate the learning around the cultural changes that need to happen in addressing, you know, gender inequity? How do we accelerate that learning? How do we support the judiciary, police, our peers in the sector to, you know, to advance and accelerate that learning? So three questions.
Okay, so I think they were directed to Donna, Hayley, and then perhaps Nadia as for Queensland. I'm not sure. So Donna, you've got your
anyone who wants to answer can jump in.
Yeah.
Okay.
I can just quickly say that I will try and pull the WA ones together, but I think they're behind the old paywall, just in terms of how they're presented. So yeah, I'll get onto them more and get them to you. And I'll share the slides, that's no problem as well.
Thanks, Donna.
So there was a question from Tanya about how do we know who's got the goldest standard? Do we think that's Queensland or not? I'm not sure. Nadia?
Sure, I don't think so.
Okay.
No, and look, I think we have some very high aspirations, but I think to Tanya's point, I think the law can drive things, but I think it can also hold us back. And I think one of the most disturbing trends we've seen in the Queensland development, so of all the 277 recommendations, many of those are really great, but it's the way we go about doing it. And I think control is a really good example. It appears from the early indications that the Queensland government is going to use the unlawful stalking provision and essentially find and replace stalking with coercive control. The problem with that is sort of myriad, but one of the primary problems with that is unlawful stalking is one of the lowest prosecuted, least successfully prosecuted offences in the state. And as my Year 7 maths teacher says, 1,000,000 times 0 is still 0. Right. So I think it's really important to think about the efficacy of laws and the structures of them rather than just sort of lazy and quick drafting. So absolutely, the law can be a really powerful tool, but when it's not and when it doesn't work, we have to think about different and better ways to do it. And that cross-jurisdictional comparison is a great opportunity. And just even looking at the WA papers, all of that work is out there. I think if you were paid by the word in this area, you'd be a very rich person. The literature out there has done so many cross-comparative studies. So I think it's incumbent upon us to bring all of that back to light, regardless of how long ago it was, because a lot of that material, regrettably, is still really relevant.
Thanks, Nadia. Hayley, did you want to comment on that?
No, I think that's all really well said. I think the law as a norm setting function is actually really important for the primary prevention that we all do. So, you know, the conversations we have in schools as a result of the law changes, it completely changes the bar of the conversation. And, you know, not away from, hey, we should be nice to each other because we say so, and because you actually care about the other person's feelings, to this is actually unacceptable and a crime. And is extremely serious. And so I think it kind of is, you know, instead of like it's really serious because of the impacts on that person that you don't actually show consideration for, or this is actually a serious crime in the community, see it as a serious crime. So you're a criminal if you're doing it. You know, I mean, essentially that's the message. And I think that I don't think that we should detract from the power of the law in setting norms and expectations around that, but it has to filter all the way through. I mean, if we still have a situation where we've got a law like that, you know, exactly as Nadia said, and we have just such a tiny number of cases where there's actual justice in practice. Well, what does that say? We're not walking the talk. And so it becomes over time, it's like, oh yeah, so apparently it's a law somewhere, but you know, it's not, I've never ever seen it actually act as a bottom line. Then it loses its impetus. But the moment in time that you change the law is a massive opportunity to do this sweeping and groundswell of primary prevention, to actually change and set expectations, have these conversations about the nuanced situations that people find themselves in relationship, particularly for young people navigating that at that point, but all the way through the community. It's such an important time. But please don't bring that law change in, or please don't let them bring that law change in unless they're doing all of the other substantive changes around it. You know, we don't want to set this law up to fail. We need to have the evidence and procedure law changes. We need to have wraparound sexual assault services. We need medical forensic access to medical forensic care so that we can actually have some evidence upon which to base that element. So these are the things that, you know, I think talk about the law and say, this is our expectation, announce that we're changing it, sure, but before you bring the law in, make sure that you do your groundwork and let them know that these procedural and evidential changes, these changes around the way people are treated and the way they experience the system is going to be your make or break as to whether this is successful or whether you completely lose this generational opportunity to change norms and expectations.
Thanks, Hayley and Nadia for that, and Donna. Look, we've got 10 minutes to go. I do have a question that is important for everyone to comment on, and I just do see in the chat that there are requests for Donna's PowerPoint in particular. A few other resources has come through from the other presenters. At the end, we'll send the PowerPoint and the presentation, any additional notes to everyone. So this is a question for everyone to respond to very briefly before Donna sums up. Alison, Donna, you're on screen. Before Alison sums up for us, we are really curious to know how were lived experience perspectives included in the reform journey in your different states, and what have the reforms meant for victim survivors? And note that we've actually only got probably a minute for each person to respond, but we'll finish on that. Would anyone like to start with that one?
Can I say one thing really quickly, because this has emerged as an issue in Tassie, where often victim survivors have wrongly assumed that the DPP acts for them, and that's not the case, right? So an indictment's issued, it's taken out in the name of the state, and so it's the state's recognised as a public interest in pursuing it. And so I really think, and Angela's put in the chat, that, you know, we need to support victim survivors through the whole process, and there needs to be specialist services that do service delivery at that level right throughout the whole process. And if we don't offer people that support, including right up front about whether they pursue a legal option or whether that's right for them, not just because of the law, but because, you know, that they're in a position where they can do that on their own trauma journey and it's in their best interests, and that's a decision for them, then we're not going to get this work right. And I think that that's really critical, and it's currently not funded.
Let's do this again, Yvette. Let's just do a whole thing on the need for independent legal representation for victim survivors of sexual assault, because absolutely, there's so much to talk about, isn't there? Thank you, Yvette. Does someone else want to talk about the experience of victim survivors in their jurisdiction? Lara, do you know if it was included in Victoria? If they were included?
I do know that the Victorian Government has a Victims of Crime Consultative Committee and a Victim Survivors Advisory Council, which was the first chair of that was Rosie Batty. So they've got kind of two key forums for lived experience input into all of their policy work, and they are consulted on quite regularly. So I assume they would have had significant input to the reforms. But I'm not sure exactly what their feedback was or how it was incorporated.
Yeah, okay, thanks, Lara. Nadia, Donna or Hayley? Yep, no.
Just a really quick one from me. Look, I think victim survivors were prioritised in the most recent reforms in terms of hear her voice. It says it on the tin. But to Yvette's point and Hayley's point, I think that needs to translate into practical experience and dealing with that power imbalance, because prosecutions are brought on behalf of the king, and we never forget that. But we still call the trial the Higgins trial, not the Learmonth trial. And as long as that happens, we haven't got it right.
Yep, great point to make, Nadia.
Yeah.
Hayley? Yep, sorry.
Yeah, just very briefly, we don't have those same infrastructure of victim survivor or, like a panel to do that in New South Wales. So the inquiry was open to any submissions, and we did our best to try to make that as accessible as possible to victim survivor advocates. But we also, brought them along to roundtables at Law Reform Commission, and when they, basically against it, we needed them in the room, and so we did what we could, and we included extensive consultation with victim survivors in our submissions, and also to the inquiries themselves. So we did our best from our sector, but certainly from government, it wasn't the same kind of hands-on approach. But I would definitely recommend that you do it. Just be mindful that when you have these advisory boards, there's a lot of power and there's a lot of power differential in them. They only work to an extent, and they all just want to please.
Can I just call you back in a moment? I'm just watching something. Yep.
Oh,
thanks.
sorry. So I think we just need to be mindful of that, and it's very hard to get a representative view. So we sort of prefer to supplement that with the survey staff, with the kind of sector responses, and providing avenues for a diverse range of people to contribute in a diverse range of ways, and try not to pin too much on an advisory panel. Yeah, advisory group.
Thanks, Hayley. Donna, any last words from you?
No, I just wanted to thank the fabulous group of women today and their fantastic insights. It's been fantastic. Thank you.
It certainly has. We've got one more fantastic insight to go, and that's from Alison Evans, who's going to sum up for us.
To summarise,
I just put you on mic. On mute for a moment.
Oh,
automatically, you might have to start again.
I was just agreeing with what Donna is saying, and it's almost impossible to summarise such brilliant women. It's been incredible listening to you all. So what I've heard in a nutshell is that laws are powerful mechanisms for social change, and so changes to WA sexual offence laws are critical and urgent. Increased reporting is an indication of the strong appetite for social and legislative change. The extremely low conviction rates compared to reporting is outrageous, and it reveals that justice is not being done. We heard that a lack of a just outcome for victim survivors of sexual assault is affected by the social and the political context. So that includes attitudes towards victim survivors of sexual assault, attitudes towards victim survivors of sexual assault within an intimate partner context. And this is the kind of political and social infrastructure that sits around the law in practice. There is a strong appetite for a reversal of the onus of proof, so that the burden is on the accused to provide that consent, to prove that consent was actively agreed to in a context that was without coercion and control or fear. Given the weight of the social, cultural and political context, jury directions are relevant and they're necessary, and reference was made to those community attitudes, and again, particularly towards sexual violence in an intimate partner context. Jury directions serve an essential educative function and will go a long way to ensure a just outcome. Work to change community attitudes towards sexual assault and sexual assault in the context of an intimate partner relationship needs to support any legislative change, as do the systems and structures that actually support that legislation. It is a once in a lifetime, once in a generation opportunity that we have in WA. We haven't had any consideration of the current sexual offence laws in a very long time. We must provide the specialist services that can support victim survivors through the legal process and to support recovery. And as many of you know, in Western Australia, we have very few services to support victim survivors of sexual assault. We have 5 very small regional ones and our Sexual Assault and Resource Centre that covers the metropolitan area. So that's it in a nutshell.
Great, thanks, Alison, and thanks again for all of our very fabulous